Hey Juanita, Mark here. How are you, Juanita? Maiden today.
Hi, Mark. How you going?
Good. You're so well organised. I'm very impressed. So today our topic is the scary stories, and this was all born of the fact that my plan is to write uh, 11 books with 9 stories in each.
A lot of stories.
99 scary stories about estate and succession planning. So that's what's prompted this, but we thought today we'd talk about some stories, some real life examples of things that have happened in the past, because I think it's all very well for us to look at worst case scenarios when we're talking with people, but sometimes people think, oh, that'll never that will never happen to me, my family's not like that, of course, that may happen with other people, but it would never happen with us. So but it does, doesn't it? People do. Bad things happen. Bad things happen to good people every week. That's right. Yeah. Pretty much how it works. So happy for you to fire off. We got some good feedback from last week with those scorecards and the questions we asked in those. So awesome. That was a worthwhile conversation last week.
And I saw that you attached the example checklist to our Facebook page, so that would be very useful for everyone.
I know, actually, I remembered I did it. So it's up there.
Good work.
Okay, so
I'll kick off with my stories. The first one these are all real life stories. So from my experience and actual real life scenarios, these are some things that have gone wrong that we've seen for clients in their estate planning. So the first one I was going to talk about is wills that are not signed and prepared correctly. So what a lot of people may not know is that a will needs to be signed in front of 2 witnesses that are there at the same time that see you sign the will. So often, people that come in and prepare their wills, they'll sign on at the bottom of every page, which is not a formal requirement, but is good practice. So you can't slip in a page later on that's incorrect. But it must be signed in front of 2 witnesses. They don't need to be solicitors. They just need to be independent people, so not named in the will, and they don't need to have any specific qualifications. What we will often see is people prepare homemade wills or will kits or notes, and this is a really dangerous space. So if you prepare a document which purports to set out your wishes, then maybe have one person sign it, or even just do it yourself, then there's a real possibility that can be put forward, which is either good or bad, depending on the circumstances, as a informal will. And what an informal will, which is actually a legal term, is a will that's made by the deceased but doesn't quite fit the formal requirements. So, for example, it only got signed by 1 person instead of 2. However, there's a lot of other things that need to be checked off before that can be passed by the court. So a good example is a recent a matter I have at the moment, actually, where a person passed away and they had a very helpful friend who was a JP, and gave them some advice and prepared a document, or prepared a statutory declaration for them and witnessed it and put their JP stamp on, etc. And this person thought that they had prepared their very last will, but unfortunately not, because it wasn't signed in front of 2 people. So that can obviously cause lots of arguments afterwards, depending on which side of the ledger you are.
You think so?
Yeah. So to give you an idea of how that's resolved, is that if someone claims that is the last will of the deceased person, it has to be an application to the court and heard before a judge, essentially, and that can probably cost $30,000 upwards. So by trying to cut costs and save money, sometimes you can turn that into a huge expense to the estate, which comes out of the estate and what is left to other people. So it can be a really unfortunate situation.
Everyone gets to share in the joy.
Yeah, and another actual example I had was a individual who purchased a will kit and filled in the gaps of the will kit, and then decided that he wanted to add a bit more commentary around that wasn't enough. And so on the back of the will kit started writing some explanations of what he had filled in on the will kit. But unfortunately, his explanations, in his own words, didn't clarify anything. They actually made the legal words confusing and had double meanings, or were in opposition to each other. So as a result, again, similarly, that will had to go to court and be considered by a judge as to what the real construction of the will was, due to the inconsistencies between what he wrote. So again, someone who thought they were going to make it nice and easy and pay $50 for a newsagent will kit ended up being, again, like another $30,000 exercise at least to get the matter heard in court and clarified.
Well, so family always loses, and the legal system in these cases seems to be the winner because you haven't done it properly in the first place.
That's right, and I mean the main issue that it's just caused so many expenses unnecessarily to the estate. So look, they are perfect examples of why, and it sounds like we're tooting our own horn, but that's why homemade wills or will kits can be very dangerous. So in some cases it's better than no will, but really proceed with caution, I would say.
Yeah, in some cases, but not many.
That's right.
In some cases, it might be better. So, what is the? Look, we all understand the actual statistics of people that have their have their wills completed is actually very, very low at any time, isn't it? And even those that have their wills completed by a lawyer, by a will kit or whatever, there's still a high chance that many of those are inappropriate. Not reflecting what the wishes of the deceased would be, and so on, because they're kind of out of date or they haven't been reviewed, situations have changed, and so on. So, when it comes to it, there's probably more people contesting wills and arguing over wills these days than ever before. Would that be a fair statement?
That is a very fair statement, absolutely. And that's a combination of increased wealth, of an increase in blended families and second families, a generation of wealth in superannuation. So absolutely.
High levels of entitlement and expectation from some of the beneficiaries, I would suspect, as well.
Yeah, and I think also more publicity about these sort of matters. Like, you'll often see the newspapers really latch onto those sensational type stories, and they're in the paper. So people are seeing and hearing more about people contesting wills, which probably raises the awareness for good or bad.
Yeah, I'd never forget the time 2 or 3 years ago when I checked into my hotel in Dubbo and, walked into the room, turned the TV on, and the thing that came onto the TV was an advertisement for, hey, are you a potential beneficiary, or should you have been a potential beneficiary of someone's estate? Give us a call, dial 1-800, we'll screw the bastards for you. Sort of, that was the kind of advertisement that it was, and I just thought, wow, it's like the old ambulance chasing lawyers and so on. It's like this ad was very much about encouraging someone who may not have really had any entitlement or whatever, but it just encouraged that whoever was watching the ad, that there was it was kind of your right, and you're expected to challenge things if you don't get what you want. And the other side of the equation is, I have a belief that if somebody writes this is what they want to do on their will, then that should be their right. That should be what happens. But I guess there's so much money, and as you say, larger wills, larger estates, and from a lawyer's point of view, in a lot of cases, and certainly not having a go at you guys by any stretch of the imagination, but I mean, the fees are always going to come out of the estate, so they know they're going to get paid.
Yeah.
So it's like, here's a pot of money. Let's see how much we can get out of this. Sadly.
The fees usually come out of the estate unless, there's some extenuating circumstances, but, not always. But at the end of the day, it's no doubt that there is money that comes out of the estate, and unfortunately just reduces the pool that's left for the beneficiaries.
So, what we're doing, Juanita, when we raise this awareness, and each couple of weeks we talk about these things, and people watch and listen and so on. But one of the things, and I was talking about this with some people that are helping me with some workshops we're putting together, is that until you get emotionally motivated to do something about your estate plan, people know they should do something. They know they need to fix it. They know it's probably not done correctly, but something needs to trigger people to make them want to come in, have a meeting with you guys, with us, and actually take action to fix what's broken or not in place. What are your thoughts on, when people come in to see you to get their estate planning done, forgetting the ones that are referred in and someone else has sent them to you, people that effectively walk off the street and say, hey, I need to fix this, I need to look at my estate planning, succession planning, whatever. What do you find is generally the motivation that's brought them in to see you?
Gee, that's a good question.
I know, there's no notice on that question at all either.
Yeah, I think often an event has happened to trigger that action, and it may not happen straight away, but it may be, a divorce, a birth, a purchase of a business, an insolvency, a separation, a large inheritance has been received. So, it might be a unfortunate illness diagnosis. So usually it's something that has really pushed that person along, perhaps. And I find that a lot of our clients, it's been on their mind for a long time, and it's something they know they should do. They'll get around to it eventually, but just to, really often need that little push to get them out. I mean, it's not fun stuff, isn't it? There's lots of other stuff you'd prefer to be doing. I think it's fun, but for a lot of our clients, it's not top of their priority list of fun things to do. So, I think it's usually something that will get them to take that final action.
Yeah, procrastination is alive and well, because people think I deal with this all the time. People think they're invincible. They think it's always going to happen to the other guy. Bad stuff won't happen to them. The other, if there's a 1 in 3 chance of someone dying, they figure it's going to be one of the other two in a group of 3. And all that sort of stuff. But, for example, today someone rang out of the blue, a Western new client rang out of the blue today. And their reason was, and they'd been referred to me through another client who's kind of a friend of the family. And the truth of their situation was that they're having issues with one of their children and his wife. And so there's conflict brewing, and they don't know whether that child wants to come in and have the opportunity to get involved in running the business. There's another son involved who's already working on the farm, and so there's this brewing conflict between, not overtly, but I mean it's underlying that there's this conflict between two of the sons, and nobody, they've had a round table conversation over the kitchen table, and nobody wanted to talk about it. None of the kids wanted to talk about it, and that's a common thing, because none of the kids want to be seen to be disrespecting their parents or arguing in front of their parents or acting entitled in front of their parents. But, sure as eggs, if mum and dad passed away last night, it's just going to be an absolute dogfight. And the parents understand where it's at, and so they've rung me. So that's, this family conflict has triggered these people to take action. And, the psychology of why people put this off, defer it, procrastinate, and don't do anything always leaves me sort of a little baffled. But it's human nature. So I wish there was a secret to helping people understand all the dangers they face by not doing something, and then you can motivate people. Hence the book.
I can't wait to read this book. So another example I have of an estate plan that has gone wrong, another real life story, is we've spoken about assets that don't fall in your estate. Things like superannuation unless it's specifically directed there, or jointly held assets. I've seen clients where they haven't received the appropriate advice try to leave things in their will which they can't, and so as a result they think that they're providing for the beneficiary or the person or the family member, when in fact they actually aren't. And a good example of this recently was a will maker where I saw a will, and he had left properties to various family members and gifted specific properties. Unfortunately, one of the properties was held as joint tenants, and for our regular listeners, you would know that that means when one person passes away, the property automatically reverts to the survivor by the principle of survivorship, and it doesn't fall into your estate, as opposed to a property that you might own with someone as tenants in common. So because this property was owned as joint tenants, it simply didn't form part of the estate, and that gift failed. So unfortunately that meant this particular child did not receive anything from the parent's estate. So the best intentions of the parent weren't achieved, and subsequently there's been it's really upset the family dynamics, and it's been caused a lot of grief with the family relationships, which is a really sad outcome. Of course, there's ways you can fix that. You can change that tenancy before one passes away, but unfortunately, even though the deceased knew that was able to be done, it wasn't done in time, and so that's resulted in this really unfortunate situation and squabble, and again at considerable expense ultimately to the estate and to the beneficiaries that the deceased was trying to provide for. So really simple little error in the will has caused a lot of grief.
So in other words, in a case like that, what would happen is that the aggrieved would contest the will. Is that what's happened? And then all of a sudden you've got all the legal costs, and depending on the size of the estate, the legal costs in some cases are going to outweigh what the cost of the benefit was in the first place.
Yeah, I guess. Quite potentially. Yeah. And, we talk a lot about the expense to the estate and how much it costs, but it's also the non-tangible things that are a resultant of all of this also. So the deterioration in the family relationships and the stress and the grief and the longer time frame to sort things out. So it's a real no-win situation.
Yeah, so people are grieving the loss of the person, but then they're fighting with their siblings, and it's never going to end well.
And I think again, if we go back to the first example about homemade wills and will kits, that's another scenario where I think that would be quite likely to happen, leaving assets that you don't realise you can't leave, and so therefore your ultimate intentions aren't carried out.
Now, when you started telling that story, I thought, let me guess, all the assets are in a family trust.
No, not this one. That's another one, isn't it? That's another cracker. When someone leaves their assets in their will, but they're actually owned by the trust or by a company, and therefore they can't leave them in their will. So that's yet another example of a little misunderstanding that can cause significant issues.
So with situations like that, Juanita, so let's say there were 4 $1 million properties that were actually all owned in a trust.
I feel like I'm about to do an exam question. I better concentrate.
No. This will be an easy one. So there's 4 $1 million properties. They're all owned in a trust, but and the trust goes to the benefit, let's say, of one of the children. That the control of the trust passes to another child, let's say. But in his will, he gives one property to each of his children. So the intention's there. So obviously, there's a $4 million estate. It's ended up with one child. 3 have ended up with nothing.
Yep.
And then, what does that end up costing to go through to sort out all that sort of stuff, or is that like how long's a piece of string?
Well, yes, but as to explain that scenario to our listeners, by the letter of the law, those assets are owned by the trust and not the individual. So therefore, that individual can't leave them in their will. What you can do in your will is pass control of the trust, and the trust will continue to own those assets. So in that situation where they might have left control of that trust to one of the 4 children in your example, it really comes down to whether that one child wants to be nice and kind and generous to their other 3 or not. And if they don't, then they don't have to, because that's the legality of it. So it can really upset the apple cart. And I suppose the next step potentially is that those 3 children may contest the will, but in that situation, who knows what's even in the estate? So if there's nothing in the estate, then that's no good either, because there's no point contesting a will when there's nothing to contest. So, you know, that can be really problematic also. But no doubt, you know, if that situation, if there was plenty in the estate, for example, and that will was contested, you know, tens of thousands of dollars, 30, 40, 50, 60, you know, thousands of dollars, depending on the extent of the dispute, can have to come out of that estate.
Now, you may tell me you can't answer this question, and that's okay. But if that was the case, you've got a trust which the control has passed to one of the children, and let's say there aren't any other assets, full stop. There's not a cent anywhere. There's no superannuation. There's no other assets. The whole estate was in the trust. Then it's kind of like, how can the other 3 contest a will in which there's no money?
Well, they won't. They can't. So, they can, but they won't get anything because there's nothing there. So that's an unfortunate circumstance. Yeah.
Okay. So just another one of those disasters, which, you know, what's the answer to people being reluctant to coming in and having their will checked every few years? You know, just a bit of a second opinion, as we call it. And I know that, you know, you do that for a number of people we bring along occasionally, is just say, you know, let's just have a look at what you've currently got and see whether it reflects the sorts of things that you said you wanted to happen when something happens to you. And you guys are very good at looking at, you know, what's in place, what's existing, and being able to make comment in general terms and say, look, you know, based on what you've said you want to happen and based on what's in this will, you're miles apart. And that then motivates, hopefully, or gives people the opportunity to do something about it. But you know, the age-old question is how to get people to come in and take advantage of that.
Yeah, I think the answer to that resistance is twofold. Is one, you know, we always recommend you review your will after a certain period of time, you know, say 3 or 5 years, or an event, like I mentioned before, a death, a birth, a marriage, a divorce, a buying of a business, etc., etc. Doesn't mean you have to update your will, but it's just really important that you review it. So we're not saying do a new will every 3 years. We're saying review it. Make sure that it still fits your purpose and your circumstances. And if it doesn't, then you may need to do a new will. I think that's the key piece there. And then secondly, I think it's useful, like we are doing today, to explain what the consequences can be. Because if someone is reluctant to pay whatever it might be for a new will, I imagine that they would be even more reluctant to basically agree to their estate being deducted tens of thousands of dollars because of the dispute that will happen afterwards because it wasn't done correctly in the first place. So I think, you know, knowing what the consequences are of it not being addressed correctly, and knowing that it might not need to be updated, the key is to reviewing your estate planning.
Yeah. Okay, we've got time. Have you got one more? I mean, you go through a lot of these things all the time. Have you got an extra one?
I do. So
a bonus one.
A bonus one. Superannuation and binding death benefit nominations are a real. A lot of people think they're really simple documents, and they essentially are to look at. But there's a lot of legality behind those documents, and if you aren't advised correctly, there can be some really serious financial implications to what happens to your super after you've passed away. So I'll give you some examples. First of all, you can leave your super to a spouse, child, or dependent. However, if you leave it to an adult child, they are taxed, as opposed to a spouse who it isn't taxed. So, and the tax is a certain proportion, 15 to 70% of the taxable component of your super. And I'm not going to go into those sort of ins and outs. But the message here is, if you don't know that, and for example, you leave your super to perhaps the super to one child and the cash in your will to another child, thinking they'll get the even amount. The fact is they won't, because the adult child that got the super will be taxed and it'll be an uneven amount. So we see that all the time. So nominating people in your superannuation death benefit nominations without knowing what the implications will be from a tax perspective, and that can again, just by doing that, make a difference of tens of thousands of dollars in tax, depending on obviously what your super balance is. Another common mistake with those nomination forms is, particularly with industry funds, most of these forms lapse every 3 years. So if they have lapsed and you haven't renewed them, then you basically have not got anything in place as to how you leave your super. A lot of the industry funds will send you an email, or usually send you something in the post or an email reminding you. But as we all know, a lot of us tend to let the inbox build up, or throw that boring paperwork in the bin. So by not renewing those nominations, that could have real consequences, and your super may not go to where you want it to go, and lots of disputes could potentially follow. So, and again, just not filling them out correctly. So if a form's not filled out correctly, for example, a lot of them will have percentages, and you need to put a total 100% at the bottom and make sure it all adds up. If there is an error somewhere, then the form is invalid. And again, we revert back to that means you don't have a form, you don't have something in place, and your super may end up in the hands of someone that you didn't want it to, or there'll be a dispute that follows. So they're all, even though it looks like a really simple form, you can download most of them off the internet. There is real significant consequences of not getting the right advice around them, and filling them in incorrectly, or letting them lapse, etc., which are really simple things to happen and regular.
Every time we chat, we just come up with so many things that can go wrong if you don't get it done properly. And I'm probably going to use the analogy, I don't know how to make vichy soir, or what it is actually. Isn't that cold soup? So if you don't know about what you need to do with estate planning, then my point is, you go to a restaurant if you want something you don't know how to cook. And in the same analogy here is that, there's so many things you need to think about that if you're not involved in this business, if you're not involved and it's not your specialty, you can't be expected to know all this stuff. And to be honest, 90-something% of lawyers too, if they're not just specialising in estate succession planning, they're not going to know all the things that need to be checked as well. And that's why coming to someone like Juanita, Murdoch's, and so on, people who actually just focus and specialise in this area, is where you need to go for a checkup. And there's nothing but in life, if you've been told you have some terminal illness, people always run off and get a second opinion. I'd be doing that with your current estate planning too. If you're not sure whether what you've got is going to be appropriate, adequate, and tax effective and fair, and reduce significantly the risk of your kids all contesting the will, then give Juanita a call and get her to have a look at it and go through her checklist to see if there might be something that she can do to help save your family when you're gone.
And I was laughing because, as we know from last week's show, I love a good checklist. So.
If you want to get something checked off on a checklist, come see Juanita. Anyway, great job. Thanks again, Juanita, for a very interesting conversation today. Hope that was valuable. We had a few people who've been watching us as we've been going live, so hope that was valuable for you, and look forward to catching up with you in another 2 weeks.
Great. Thanks, Mark. Thanks, everyone.
See you then. Bye.